Good morning. Happy Tuesday. So people love to think I'm biased when I have an opinion regarding legal documents that doesn't align with what they want to hear. And today, I'm going to disappoint a lot of people, and I am biased in this particular instance. I am particularly biased when I read pleadings that comport with my understanding of the law. Now, a lot of you out there have knowledge of facts that I don't have. I typically, if I can help it, avoid extraneous knowledge of facts that would not be in front of the judge. So I haven't watched all the fraud or troll videos. I haven't watched the DMA videos. I haven't watched Randy's videos on the subject. I look at the pleadings because the pleadings are what the court's going to have in front of it. The pleadings are what the court is going to make the determinations on, the motion practice, the declarations, things like that. And so my analysis might not comport with your broader understanding or misunderstanding, as the case may be, of the facts of the case, because I am basing everything on what the judge would see, because that's what the judge would see, and that's what the judge would make her ruling based on. There was a continuance granted. Lou got a small slap on the wrist for failing to comply with local rules regarding how he's supposed to give the chamber's copy to the judge. Minor, silly thing. Don't read anything into it. The court's probably not going to remember it unless he does it again, and I doubt he'll do it again. Minor slap on the wrist, no big deal. But also, Randy filed his opposition to the administrative motion. He has not filed his opposition to the forum nonconvenience, but he did telegraph a little bit of what he's going to plead. And I have to say that in my bias, Randy saying the things that I thought he should say, for the most part, really biases me in favor of thinking that he has the better position on the motion to stay. The forum nonconvenience motion is particularly weak. I said that in my previous video. The very short, truncated opposition as set forth in the response to the administrative motion to stay discovery and stay ruling on the, I guess there's the attorney's fees portion of the anti-SLAPP motion to dismiss and dismissing. So it seems like he has a motion to dismiss all of the counterclaims, but I don't recall that, and I haven't gone back through to read, but that's kind of the impression that I was getting from the opposition to the administrative motion. I could be wrong on that. I don't remember there being a motion to dismiss all of the counterclaims. I thought it was just a motion to dismiss some of the counterclaims. But it seems to me that he has a good argument on the forum nonconvenience because the defendant has availed themselves of this court for quite some time and has stated in a joint status update that this is the right forum for this case to be heard. And now for procedural reasons, they think they'd get a better shake in a Canadian court, and that's fun and fine, but it's a real hard sell to a court to say, yeah, I've been taking advantage of the processes available in this court, and I've stated that this is the correct court for it for the last 6 to 9 months, however long it's been, and now all of a sudden, oh, you know what, Canada would be a better forum for it. And again, it is a U.S. plaintiff, U.S. law. The materials are on YouTube. The subpoenas are going to YouTube, which is a U.S. company. I just don't see the court granting the motion for forum nonconvenience. That's not saying the court can't, but the odds, as I estimate them, are low. So why would the court grant the motion to stay discovery if it's not going to grant the forum nonconvenience? That's a very good argument. In addition, I also thought that the motion to stay discovery had a equity issue, because the defendant, Fraud or Troll, was asking to stay discovery for the plaintiff, but allow defendant's discovery to proceed. Courts, generally speaking, like to keep things fair. One side can't engage in discovery if the other side can't. And apparently, there's a very big discovery issue. I remember hearing about Fraud or Troll deleting a shit ton of videos. That is a legal term. Shit ton means a lot. He deleted hundreds of videos. And apparently, he deleted videos that DMA claims had copyrighted materials in them, and alleged them generally in his complaint. And apparently, according to Randy, who I would hope wouldn't lie in a declaration to the court, Fraud or Troll has not produced these videos as part of discovery. And it's kind of weird, discovery going on for this long. I mean, you have your initial disclosures that are due relatively quickly in a federal case. And discovery should take 2 or 3 months if you're on the ball. I'm assuming Randy is on the ball, which is an assumption. But 6 months out, if you don't have videos that you've identified for the defense to produce, that means there's most likely a problem. And that's going to have to get sorted out, because my base assumption is that when Fraud or Troll deleted these videos, he didn't keep copies. That's called spoliation. There are lots of remedies for spoliation, up to and including issue preclusion, claim preclusion, having a jury instruction saying that the jury has to infer that the materials that the defense didn't produce were detrimental to the defense's case. So, I mean, they could get a jury instruction that would say that the jury has to consider that those videos, in theory, they could get a jury instruction saying something along the lines of those videos contain copyrighted material, and Fraud or Troll violated the copyright on them. You have to infer that they did that. So it's a big deal. Spoliation is not something a person who knows that they are being sued should engage in, because there are remedies for it. And especially when the materials are on a public platform where people can notice them disappearing. So speaking of which, like, if he had just made them private, kept them on YouTube, made them private, or made copies of them and then deleted them, one of those two, it wouldn't be spoliation. He could then just produce it. It would cut off damages from the time that he prevented the general public from being able to view these videos. So that could go to mitigating damages, but it wouldn't be held against him. But my base assumption is that he actually deleted them, and he cannot produce them at this point because he doesn't have copies, or else he would and should have produced them. I'm sure his attorney told him, if you have them, you need to produce them. So this is all bad. This is all bad. And again, my base assumption is that Lou, and yes, I know that's not his real name, is playing for time and playing for procedural hurdles to frustrate Randy and DMA and to block time. Oh, in the bond issue, Randy had a good point on that. Like, the bond issue is fine and dandy, and I think from the tone and tenor of it, I think Randy concedes that the court will probably order DMA to pay a bond, post a bond. But Randy had a good point. Look, they're going to owe us attorney's fees. We should resolve that And then maybe the attorney's fees they owe could be the bond. Makes sense to me. I'm not saying that's a winning argument as far as the bond issue is concerned, but a better issue is that the bond doesn't justify a stay of discovery. The bond issue does not justify a stay of discovery, and it does not justify not ruling on the attorney's fees issue. Only the forum nonconvenience is really reasonable grounds for the stay of discovery. And Randy had a good point. Like, look, I can't really address all the issues in the forum nonconvenience because there's a page page limitation on opposing administrative motions. And I'm going to need more pages to actually fully brief why the forum nonconvenience isn't going to work. But here's a truncated version, a shortened version, hitting the highlights of why I think that the forum nonconvenience isn't going to prevail. So that's again, I see very low odds of success on the stay, but it is creating churn. It's creating, like, Lou's getting paid for it, so that's great. And it could be part of the strategy, again, to hopefully frustrate people into the point where they want to settle. So yeah, my bias in this is very clear. I had a pre-existing kind of, not seeing any opposition from Randy. I think low probability on this, good probability on this, etc. Low probability on this. So low probability on forum nonconvenience, high probability on the bond, and low probability on the motion to stay. Randy's basically making arguments that kind of confirm my beliefs. So that is a bias, and I can't get around that bias. That is a baked-in bias. It's not because I like Randy. It's because he's making the arguments that were in my head that I was kind of expecting, plus some extra stuff. And I'm like, yeah, his view of it is the same as mine, so that is a bias. Switching gears to Common Joe, he's filed a motion for retrial. His strategy at trial was telling the jury, go ahead and find me guilty. I know I'm not going to get a fair trial. I'm just going to take this on appeal. That's bad strategy. That's like the worst strategy you could have. And his motion for a new trial is basically the same strategy. I know you're not going to grant this, but these are the issues that I am raising, and none of the issues were good. I didn't see any good factual basis for any of the issues that he raised. And I really know I'm not going to win on the motion for a new trial. I'm just doing this because I have to do this to preserve my right to appeal. Again, terrible strategy. Very low odds of success on the motion for a new trial, unless he has. And the bad thing is that he's kind of limited to the arguments that he's making on the motion for a new trial, and they're not good arguments. But those are the arguments that he's going to get to make on appeal if my understanding of Missouri law is correct, and it may not be because I'm not licensed to practice in Missouri, so take all this with a grain of salt. I am just a first-year family law attorney from California, and as one of my commenters suggested, that I acknowledge that I have limited brain cells. I do have limited brain cells. Everybody does. I don't know why that helps him. He also says I should shave the beard. That's not happening. I like my beard. I think beards are very masculine. Not that a beard makes you more of a man, but men have beards, and I like beards because I'm a man, and I fancy myself to be a fairly masculine man, and, well, I think the beard fits me, and it fits my face, and my wife likes it, so, my kids like to pull on it. They're adorable. Anyway, so it's a very bad strategy on Mr. Pierce's part. And then finally, in Iran, it appears that the director of the National Counterintelligence Department, I could be slightly wrong on that, issued a resignation letter that was made public, basically saying all the things that I was saying. There was no known threat by Iran. This war was primarily driven at the insistence of our greatest ally. There was air quotes on that if you weren't watching the screen. They are, again, not our greatest ally. They are barely our ally because I believe we have unilateral agreements to defend them, but they have no agreements to defend us or our interests. So barely an ally, if that. We're their ally. I don't think they're our ally, if that makes more sense. But he's saying all the things that I was saying. You know, our fearless leader, our very stupid leader, has kicked a hornet's nest. He's in a pickle. He doesn't know how to get out of it. It is causing major damage to the world economy. The world is not super keen on us. He's asking for everybody under the sun to come and help him unblock the Strait of Hormuz, because I think our military has been pretty adamant we can't do it. Mr. President, I know you want that strait unblocked, but we can't do it. We don't have the capability of doing it. They've got all the cards. And so he's been pleading with other countries to come in and basically save us from the predicament we got ourselves into. And they're all noping their way firmly out of it. And he keeps tweeting about how, you know, Iran keeps reaching out to him for peace, and Iran keeps saying, no, not happening, didn't happen, hasn't happened. And then he said the other day that that the last 4 presidents have I'm crudely paraphrasing this because I don't remember the exact quote, but something along the lines of the last 4 presidents all applauded his decision to go in against Iran and all said that it was the right decision and that they should have done it. And all 4 past presidents are like, no, we have no communications with him. We didn't tell him that. The dude is on another level. I don't know if he's crazy or he's lying or both. But like nothing that he says makes any sense. This was a very poor decision to make. They have acknowledged about 200 dead U.S. servicemen. We've had all sorts of mysterious accidents and illnesses and whatnot that aren't related to combat. It's crazy. We've lost how many tanker planes? We've had mysterious fires in our carriers that have all moved far away from the shores of Iran. They're all like 1,000 kilometers or more away from Iran, which reduces their ability, as far as I understand, to accomplish the mission that they have of blowing up police stations and schools and hospitals and all sorts of insanely critical military targets like that. But it just doesn't, like, they've admitted to 200. How many have actually died? I have to wonder. Like, Iran's posting satellite imagery. Maybe it's fake, maybe it's not. But it's somewhat corroborated by the limited videos that do get out of these places showing the drone strikes and showing the missile strikes. But they show video after video of massive damage to U.S. bases in the area. There's our base in Baghdad is being attacked by the Iraqi resistance. Like, it's under a lot of pressure. I mean, it's just this war is just all bad, and we had no plan going into it. Trump basically admitted that he did it because he was pressured to by our allies in the region, and he named our greatest ally, specifically our greatest ally in air quotes. And he fully expected that we would go in, we would do shock and awe, we would take out their leadership, and they'd fold like a house of cards. And then when, like, he had no backup plan, zero backup plan. We can't really damage their military capabilities, so we blow up civilian infrastructure, oil fields, power plants, police stations, all to no effect. Like, it has not seemingly had any impact on their ability or will to continue this. I've seen videos out of Israel, like, they're just being pounded to piss. There's like craters everywhere. Sections are looking more like Gaza than anything. The airports are being smashed. I mean, it's just all bad. So it is just a ill-conceived operation, and there's no win. There's no win condition. Never get involved in a war where there isn't a win condition. Like, how long did it take them to even come up with a salient rationale for it? Or have they even? I mean, they've offered several, regime change, getting rid of the nukes, getting rid of their ability to produce and shoot rockets, blah, blah, blah. I mean, like, we don't even have a set win condition. Maybe unconditional surrender. We don't have a set win condition. Like, so how can you win if you don't have a win condition? They have a win condition. They can just outlast us. They're still standing at the end of this. They won. All stupid. Anyway, I'm going to stop rambling. Thanks for watching. Have a great day.